Started. We have a classroom here from Bergman Academy. It's my understanding that is a middle school. Is that correct? Guess what? Each and every one of us on this bench went to middle school too. And so we are going to tell you where we went to middle school. So they're used to answering the high school question. I'm delaying now so they can all try and remember really quick where they went to middle school. So first of all, welcome to this public proceeding with the Iowa Supreme Court. It's my understanding your teacher, Ms. Peck, is here as well. Thanks for making the trip. My name is Susie Christensen, and I went to the Harlan Community. It used to be called junior high. They've changed it to be middle school. But I went 7th, 8th, 9th to junior high in Harlan. And I'll go to my right and then left, back and forth, and that's how we go for the order of seniority on the court.
Hi, I'm Tom Waterman, and I went to Bettendorf Middle School, grades 6 through 8.
Ed Mansfield. I grew up in Lexington, Massachusetts, and went to the Lexington Public Schools. That's where the American Revolution started. So there were 3 middle schools, all named for various figures that were important in Lexington history. I went to William Diamond Junior High School. William Diamond was the drummer who summoned the militia to the Lexington Green on April 19th, 1775.
Good morning. I'm Christopher McDonald. I went to McCombs Middle School, and I have 3 kids who went to Bergman Academy.
My name is Dana Oxley. I went to Greenfield Junior High, which is now Nottoway Valley.
I'm Matt McDermott. I went to Holy Spirit Middle School in Carroll, Iowa.
My name's David May. I grew up in Missouri. We didn't have much activity in the Revolution there, but I went to Kirksville Junior High.
Thank you. When the attorneys approach the bench, go ahead, or approach the podium, go ahead and tell us where you went to middle school. And we'll start with, am I correct, it's pronounced Peterzalek? Am I close?
Peterzalek, Your Honor.
You may go first, and then tell us where you went to middle school.
Thank you, Your Honor. I grew up in the Cedar Rapids area and went to C.B. Vernon Junior High School.
Proceed.
May it please the court, counsel.
To announce, this is the case of Hedlund versus, excuse me, Hedlund versus State of Iowa and others. Sorry about that. Go ahead.
Jeff Peterzalek, along with Bill Pearson, representing the defendants in this case. The issue before the court today is whether the 2019 amendments to the whistleblower statute apply to Mr. Hedlund's whistleblower claim that was made in 2013. I'm going to try to get ahead a little bit of a question, I think that, or comment that Justice Waterman made in the last argument, which was the amendment to the statute and what did it contain. This amendment to this statute, to the whistleblower statute, was not something that just clarified existing or pre-existing law. It's something that created an entirely new consequence or obligation by adding civil damages to the statute. It established an entirely new rule as far as who you could report certain disclosures to. So there would be potentially liability going forward that wasn't there wouldn't have been a case in the past.
Is that amendment at issue in this case?
The one I just mentioned, that issue, well, it is to the extent that it's part of the amendment to the statute, which makes it much more than a clarifying statute. Factually, the issue in this case is the consequence or obligation that's attached to the addition of the civil damages to this claim. Yes, Your Honor. As we've noted in our briefing, the court has seen this case before. In fact, the court has seen this case twice before. In 2019, in June of 2019, just prior to the effective date of the amendment, the court issued its last decision in this case. In that decision, the court made it very, very clear that Mr. Hedlund, under his whistleblower statute, the Supreme Court in that case affirmed the dismissal of all of the other claims other than the whistleblower statute. With respect to the whistleblower statute, stated that the relief was equitable and remanded it for a trial based on the equitable provisions of the prior statute, or the statute that was enacted at the time, or in effect at the time. So we go back on remand, and we're litigating the case, which ends up getting delayed for COVID and for other reasons. The plaintiffs attempted to add all kinds of different claims, which were eventually unsuccessful. And then at the very end of the process before trial, asked the district court to allow the 2019 amendments to the whistleblower statute to apply to his claim. The district court granted that request, relying or utilizing in part statements made by individual legislators, including a prior newspaper article, which included some quotations of some legislators, to evince some legislative intent that there was an intent that that statute be applied retroactively. That generates this appeal, which we're here before you today on. And there are a couple of different potential analytical approaches that the court might take for this. I'm not sure if the court is at a crossroads or what with respect to the analytical framework and analyzing retrospective application.
If it's a substantive change, then we say it is prospective. If it's a procedural or remedial change, we have said it is retrospective. Where I struggle here is it seems that, the remedial aspect of this statute, it deals with a remedy, but it seems to have a lot of substance to it, right? It seems to be a pretty substantial change, but again, it is part of a remedy. What do we do with that analytically?
It has already been addressed in the Dindinger case that this court decided, where there were amendments to the Iowa Civil Rights Act. That issue was specifically, or more specifically, addressed even in the U.S. Supreme Court's decision in Landgraf, where even if it is a remedy, if it's a remedy that attaches new legal consequences to a prior act, in Dindinger, they used the term obligation. If it attaches a new obligation to a prior act, that's deemed to be substantive, even though it does deal with the remedy. So I believe this.
About Dindinger, in that case, wasn't the, it was the liability that was changed. Didn't it become a strict liability, so the standard changed as opposed? Okay, and is there a standard change under this statute, or is it just, it's the same standard, you just have different remedies?
Well, the standard changed with respect to the issue that we decided didn't have a lot to do with this case, but with respect to the remedy, it did add that additional remedy, which involved an entire new classification of damages and liability that the state would be involved for.
Same, is it that once you've established liability for the other damages that were already allowed, or the other equitable relief that was allowed, because this is an equitable proceeding, does that automatically bring into play the additional remedy that was added, or is there a difference in the liability that would also need to be established?
The issue, well, the statute itself deals with, and even the amendment specifically mentioned, the statute addresses disclosures of information and reprisals for that information. So that aspect didn't change. There's still liability for disclosure or reprisals for disclosure of certain information that's protected under that. What has changed from a liability standpoint is that inclusion of civil damages, which can incorporate any number of things from emotional distress to reputational damages.
Kind of, I think our cases are maybe a little hard to reconcile, a little bit all over the place, but it strikes me it would be a little unfair to say if the legislature narrows the damages that are available, that can't be retroactive, but if it increases the damages that are available, that can be retroactive, because it just depends on whose ox is getting gored. It's the same unfairness to either side. One side is going to be subject to greater liability, and one side is going to be subject of have fewer damages available or whatever.
That it exposes the cite bringing the claim to any more liability. They wouldn't have liability to begin with. But I think the distinction with your question, Justice Mansfield, is that in this case and other similar cases, it attaches a substantial obligation or consequence to something that didn't exist before. Whereas if it was a reduction in damages, yes, that assists the defendant, but it's not necessarily a decrease in the ability to pursue the claim.
It's the state. But if it's two private parties, it seems to me it's unfair to a defendant to say you're going to now be exposed to this liability, this greater liability you didn't have before, and that's okay. But to say to the plaintiff, we can't reduce your potential recovery. It seems if it's unfair to the plaintiff to do the latter, it should be unfair to the defendant to do the former.
To future cases, so everybody's put on notice at that point. Where I thought Justice McDermott was going with maybe the crossroads question was, how exactly does the Supreme Court analyze these cases? We've talked a little bit about the substantive and remedial and procedural categorization or categorical process, but in 2021, Herbeck came out, and in Herbeck, it did an entirely different analysis of that same question, where you determined the correct temporal application of the statute, or in this case, the amendment. And there's a three-step process in doing that. And that really goes to the point I made before, is something that attaches a new standard, a new rule, or a new consequence to a prior act. That is deemed to be retroactive application. That's the first step. The second step then is there express legislative intent to make it retroactive? In this case, clearly, as I've said before, there has been an attachment of a significant new obligation to prior conduct. There is no express legislative language that would indicate that there's an intent to make it retrospective. And
how would you respond to the argument that the legislature acts sort of recognizing or understanding what our prior cases have held, and that we have said remedial statutes apply retroactively? Could the legislature have, again, simply been thinking, well, we know that it's going to apply retroactively because this deals with a remedy, and therefore not have included express language to that effect?
that just because it involves a remedy, if you look at the cases, doesn't necessarily make it a remedial statute. If you look at, I mentioned Dindinger, I think it's at page 563 that has the language in there regarding the fact if there's an obligation, that makes it substantive, a new obligation. If you look at the other cases, Anderson Financial, in those cases where there has been a significant change, regardless of the categorization, which is the criticism of the categorical rule to begin with, is that it can be, it's kind of, if you know it when you see it. And if that's the case, then is that retrospective or not? So there are cases, I'm sorry?
Does it say that when there's already an obligation and it's just providing additional remedies, then that is retrospective. I think, I mean, I don't disagree with the, are we at a crossroads and maybe there's a different way to do it, but it seems like we've got a lot of case law that we're going to have to do something with if we accept your position.
The point I'd make is I think if you go through regardless of the analysis you use, whether it's the categorizing or categorical analysis, whether it's the process that was used in Herbeck, you end up in the same place, either way in this particular case. And in most other cases you are too. If you look at the event of legal consequence, which by statute in the whistleblower case is going to be the reprisal for the disclosure of information, which happens in the past, and the new amendment changes the consequences for that. And that's something that is clearly a retrospective application under Herbeck, and without that express legislative intent, you can't do that. Under the categorical approach.
Undo everything that we had said before Herbeck?
Sorry, say it again.
Herbeck essentially overrule what we had done in several other cases prior to that?
I think effectively so, yes. I mean, that was a decision. Even there was a concurrence and a dissent in that case, but the concurrence went along with the retroactivity analysis of the majority.
Limit Herbeck, though, is, in Herbeck, what we said was, it actually was not retrospective because what we were looking at is when you're filing things, and that actually was a prospective. And here, I think you've said, what we're looking at is applying a new remedy to prior acts. So how do you get beyond, if we limit Herbeck to its facts, are we still going to have to overrule or at least address those other cases?
If you decide, if the court decides that Herbeck is the approach going forward, the foundation of which was laid by Scalia concurrence in Landgraf, which we cite extensively in our briefing. If you go with that, I think that there's going to have to be, I would think, some language that would indicate that we're not using the prior approach anymore, whether that's overruling, however that would be done. But I think the point I want to make clear, or at least the hope I make, is that it doesn't matter which analysis you use. If you look at the language that this Supreme Court set out in Dindiger, if you look at the language the U.S. Supreme Court set out in Landgraf, including Justice Scalia's concurrence, under any analysis, the addition of the civil damages, which was the case in Landgraf, where there were only prior equitable remedies available under Title VII, and civil damages were then added in. In that situation, the majority indicated those are substantive changes. We're not going to apply those retroactively.
It's where, again, I think the cases are not consistent. Iowa Beta chapter, we said, although we do not allow a statute to apply retrospectively when the statute provides an additional remedy to an already existing remedy or provides a remedy for we do allow a statute to apply retrospectively when the statute provides an additional remedy to an already existing remedy or provides a remedy for an already existing loss. Why isn't that what's going on here? It's an additional remedy to an already existing remedy. And in that case, it's 2009. It's not that old.
Language was set out in that case as sort of the standard that was not dispositive of the issue in the case, in the Phi Beta case. Yes, that was clearly dicta. The issue in Phi Beta was whether 669.5 substitution statute applied retroactively or not, and that simply isn't the case. Isn't the case here.
From Lembrecht. So what do you do? How do you distinguish Lembrecht?
That's there too, and in those cases, keep in mind, certainly in the Phi Beta, there wasn't any retrospective application. In Lembrecht, there were using what I'll call the older analysis, there was an indication of legislative intent. It was a new statute. When you go through and use what I refer to as a test within a test, if you determine it is remedial, and that would be, I guess, the final point I'd like to make, I'm almost running out of time, would be even if you determine the statute is remedial, that's not the end of the analysis. That just gets you to another three-step test. And in that three-step test, those steps come down in favor of the defendant on all three of those issues. We've talked about the evil to be remedied. There was already a robust pre-existing statute, and then there clearly isn't any legislative intent to make it retrospective.
In a few minutes. Thank you. Thomas Duff.
May it please the court, counsel.
I know your time is valuable, but can you, because this case, it's been a while, can you kind of recap the sort of a thumbnail sketch of what the case is about, the underlying merits?
Certainly. The case arises out of Agent Hedlund was on duty at the time and saw a black SUV going down one of the highways, I forget the highway number now, going 90 miles an hour. He was tracking the SUV, eventually got a hold of the state trooper and a sheriff, and the trooper pulled up next to the van and noticed it was the governor's van. Another trooper was driving the car, and Agent Hedlund then felt that that was a violation of the law because he was going 90 and I think it was a 65. and reported it. He sent an email shortly thereafter to then director of the Department of Public Safety, complaining about the speeding SUV. That forms the basis, among other things, the basis for the 70A.28 complaint.
And then he was terminated after that. Is that what happened?
Within, I think, less than a week, he was placed on administrative leave. There was a lengthy investigation that went on for a couple of months, and then he was eventually terminated in July of 2013, almost 10 years ago. So this case has obviously gotten quite long in the tooth. And this is our third trip before this court. I want to address for just a second, in Hedlund 2, where we did raise the issue of whether we were entitled to compensatory damages under the old statute, and the court said we were not, sent it back, and at the time it was argued and briefed, there of course had not been any legislation had not been passed. I'm sure it was being worked on. At the time the court rendered its decision, there was a bill pending, but the bill was signed after the court's decision, and that's the bill that's at issue here. So when it went back to the district court is when we made a request for compensatory damages, and along with that, because it's a law issue.
But after argued, but it didn't go into effect until July 1. Okay, all right.
Signed in May, and it would have gone into effect in July 1.
Probably not telling you a secret, but with the way we work on opinions, that opinion could have already been substantially done at the time that legislation is approved in some kind of editorial process at that point.
There was a footnote in the opinion that legislation was pending, but of course, the issue of whether the statute, the now amended statute, applied was never before the court. So the defendant has made an argument that that's the law of the case, and there's no way it could be, because the issue was never before the court at the time Hedlund 2 was issued. Of course, now the issue is squarely before the court.
Earlier, Justice Mansfield had asked, I think, kind of an issue about maybe fairness as the parties are planning or making employment decisions. And in this context, I guess I want you to respond to this thought of frequently employers get counsel or advice as they're making employment decisions, and they are thinking about employment litigation-related risks. And as they're making these decisions, it seems somewhat unfair that they've made a calculus, right or wrong at the time of termination, but now there are additional consequences that potentially could be added onto it 10 years after the fact, that maybe they would have done something different if they knew what the formula was going to be at the time of trial. So not a great question, but I think you're getting the gist of it. Could you respond to that?
One, before Hedlund 2, we had made requests. Well, let me back up. There were claims already, other claims pending in his complaint. There was a defamation claim. There was a Iowa Civil Rights Act claim. Those claims have all gone by the wayside, but all of those claims would have included damages, compensatory emotional distress, damage to reputation type damages. So while the case has been pending, those were damages that were certainly the state knew there was some exposure for. And I think to sort of address the other part of your question, the cases, and I think Justice Mansfield was talking about this earlier, in terms of we believe this is clearly a remedial statute, and that the fact that it is simply adding a remedy to an already existing statute.
I was thinking along the same lines as Justice McDonald. Let me say it in a different way. If my parents told me growing up, Susie, if you don't come in by curfew, you're going to be grounded for a week. might be worth it. I might stay out with my friends. It's worth it. I'm okay with that. But then if they changed it to be, you're going to be grounded for a week and we're taking away your allowance for the next month, I might think twice about it. I think we're underestimating perhaps the significance of civil damages in an amount not to exceed 3 times. Doesn't that just seem more substantive?
It certainly adds a layer of damage, and I think in your example, what you're talking about may be more akin to a punitive damage than compensatory. But I'm sorry. So I think the answer to that is, one, this was a compensatory damage was an element of some of the other claims that were pending, so the state had notice. And two, the case law is pretty clear that when you have an existing statute and you allow for an additional remedy that didn't exist before, that still makes it retroactive. And the case that we cite is the Schmidt v. Jenkins case, which is the amendment to the Wrongful Death Act that allowed women to recover the same amount as men, which was a new liability that did not exist, a new exposure that did not exist before.
But gosh, exceeding 3 times, that sounds like treble damages. I mean, isn't that kind of similar? I mean, I think, couldn't an employer look at that as being punitive?
I think that I look at the 3 times as a cap, because it is a limitation on the amount of compensatory damages you can recover. So I don't think it's treble damages. I think what the legislature is saying is your compensatory damages are capped at 3 times your pay and benefits.
Speaking of caps, I'm wondering if there, in your mind, is a sort of outer limit on this, because maybe it is fair and remedial to add a small amount of damages, or relatively small, 3 times wages, but is there an outer limit? I mean, 20, 100 times, before it becomes fundamentally unfair to add new penalties or at least consequences to 2013 behavior?
I suppose there could be an outer limit. I mean, I think in this case, what the legislature did was certainly impose damages that have been well recognized. They're compensatory damages. They're damages that are meant to make the person whole. So I think the example you're giving, probably that might be too much, but when you're simply trying to make the injured party whole, that does not seem to me to be excessive or in any way.
Remedy or a legal remedy?
The compensatory damages would be a legal remedy. They're capped, but that would, yes, it's money damages, so it'd be outlaw.
I think Mr. Peterzalek has a point that there's sort of a grab bag of cases out there, and you can kind of draw different conclusions in different cases. I quoted that Iowa Beta chapter that language seems to support you. Additional, if you add on a remedy, that's remedial, and that can be retroactive. But then in that Iowa Comprehensive Petroleum case, we say a remedial statute is not always applied retroactively. And then the court talks about a 3-part test, the first part being whether the legislature intended it to be applied retroactively. Not maybe the world's most helpful test, but that's another part of our law. I mean, how do we reconcile all of these cases?
I think the court has developed, particularly in Your Honor's case and the Dindinger case, sort of went through the analysis with these sorts of issues. I mean, we would agree that, I think both parties agree, there's no express language in the statute making it retroactive. So we go to the next question, which is it remedial versus procedural? If it's remedial, then a presumption is created of retroactivity, but we then have to move, which I think the defendants have the burden of rebutting.
Why don't we revert to what Iowa Code Section 4.5 provides, which says a statute is presumed to be prospective in its operation unless expressly made retrospective. I mean, here, it seems that this test that we have, where if it's remedial, there's then another three-part test under it, and that test involves us divining legislative intent from that. It seems like we have a pretty clear way that we can speak to the legislature, which is simply pushing back with their own words. If you want it to be retrospective, say so. Otherwise, we're going to go with what we, I think, sort of talked about in the Herbeck case, which is it's going to be prospective.
Well, I think that the body of case law that's developed essentially says that it is an exception to the Section 4.5, and that the court has attempted to, over the last really 50 or 60 years, the court's developed this test for determining whether a remedial statute is retroactive or not. And yes, it would, I'm sorry. I was going to say, and yes, it would be better if the legislature would just say something's retroactive, but they don't, as the courts can probably appreciate, they don't do that a lot. But there are certainly situations like Agent Hedlund where the case has been pending 10 years, and his case was pending at the time the statute was amended.
We have a code provision that says statutes are assumed to apply prospectively unless the legislature says otherwise. And then we have a body of case law that says if it's remedial, it may or may not be applied retrospectively, depending on what four justices say. That's the uncharitable version of that case law. So I guess my question to you is, why? What is the presumption of retroactivity that applies to remedial versus substantive? I guess normatively, why should we presume that remedial statute should apply retrospectively?
I think what the cases say is that if it's the difference being if it's substantive, like we actually have this in the amendments to 78.28, where they expanded the persons to whom it can be reported. That is clearly substantive because it creates a liability that did not exist before. But when you have a remedial action or a procedural, I think the idea is that it's there to prevent injustice and unfairness to litigants who have cases pending while some piece of legislation is enacted.
If the legislature passed a statute where they define for themselves the operation of future statutes and how those should be applied, why should we assume they intended something to be retrospective when they didn't do it?
Well, the court has had this case law that's, like I said, 50 or 60 years old, and sometimes there is language, and I think it is in this case, which would indicate that particularly the remedial portion was intended to be applied retrospectively. I guess the answer to that question is, the court has, I think, wisely chosen to develop a body of case law that seeks to sort of strike a balance between when the legislature clearly says something and when they don't. So I see I'm out of time. I'd ask that the court affirm the decision below. Oh, sorry.
I want to talk a little bit about land graph, just one question. That seems to be fairly close on point. To the extent that you think it's relevant, how would you distinguish the land graph case? Not the Scalia concurrence, but the actual holding relating to this similar issue.
So, one, we think land graph is, it's federal law. From a factual standpoint, it is distinguishable because the case actually indicates that in 1990, they passed the Civil Rights Act. It had a retroactive provision in it. It went to the president's desk, and the president did not like the retroactive nature of those provisions. He vetoed it. Congress went back to work. They passed the bill again without any retroactive provisions, and then it went into law. So when the Supreme Court is looking at it, they're clearly looking at that history, and not too hard to divine that the legislature did not want that statute to be retroactive. I think my other response to the Landgraf case is that if there is language in the Landgraf case that I think supports our position that adding a remedy that is a remedial and that can be retrospective. It's in the footnote 37 to that decision. And I think the other issue on Landgraf is that if the court were to adopt that, I think what essentially happens is that this 40 years of precedent, the test that the court has developed, which I think is, tries to be as fair as possible in terms of determining whether there is a retrospective application, sort of goes out the window. And I just don't think the Landgraf case is particularly persuasive because of all of those reasons. Thank you. I should say too, my son Jim, who is my law partner, and I both went to Holy Trinity Grade School in Beaverdale.
Listening earlier. Your co-counsel went too. Come on up.
Thank you, Your Honor. Mr. Pearson went to middle school in Michigan. I'm not sure exactly what the name of it was.
It's Beagle Middle School in Grand Ledge, Michigan.
Cool.
To follow up on some of the questions that were asked, some of the statements made by Mr. Duff in his argument, first of all, Landgraf, the U.S. Supreme Court decision in this case, I don't know how it could be more factually and legally analogous to the situation. It's the same situation factually / legally in that prior to the 1991 amendments to Title VII, you could only get equitable relief. After the 1991 amendments to the Civil Rights Act, you could get civil damages, exactly the same situation here.
You could also get punitive damages. There was no cap on the compensatory damages. I mean, that still was a significant difference. And what do you do with the fact that, as your opposing counsel just mentioned, that the president actually had vetoed the original legislation that included expressly a retroactive?
Landgraf itself deals primarily with the imposition of those civil damages. Yes, it knows those other items of damages are involved, but it's based on the fact that it changed the statute from equitable damages to civil damages. That's what the focus of the case was on. That was a substantive change that wasn't going to be applied remedially. The second part of your question with the one Congress saying that it should be retroactive, another Congress after the president threatened to veto or did veto that it wasn't, is exactly the criticism of that approach to trying to discern legislative intent, which was the concurrence by Justice Scalia in Landgraf, and then also forms the foundation and the basis for the Herbeck decision, and is particularly relevant in this case because of the district court's reliance on a newspaper article and a statement or quoting of a statement from an individual legislator to try to discern legislative intent. That really kind of segues into the next section, is what Herbeck does is does give effect to Iowa Code Section 4.5. That's something that was noted, I believe, by Justice McDonald in his dissent in Mackey. It's like, hey, what about 4.5? That's something that we should give some effect to.
We have a lot of cases after 4.5 was enacted that says that, well, that applies if it's substantive, but if it's procedural or remedial, if it adds remedies, then we're not going to change it. And even in Landgraf, the Supreme Court there said procedural issues like the addition of a jury trial would apply retroactively. But under 4.5, a strict reading of 4.5, we wouldn't have that same reading then of procedural. So is your suggestion that if we follow 4.5, then we entirely get rid of remedial, a retrospective application of procedural statutory changes as well?
Categorical approach was discarded in Herbeck, so I don't know that, so yeah, I think maybe you do get rid of it at that point. But even if you don't, this idea that just because it's a remedy, it's remedial, I don't know that that's accurate. And the point I wanted to make, if you look at the Schmidt case, which the plaintiffs rely on heavily in their briefing, was a 1967 case. And one of the things I think gets lost is, I believe it was 1971 when Iowa Code Section 4.5 came into effect. So a lot of these cases that cite to the provisions you're citing to, Justice Oxley, are actually cases that were decided before 4.5 came into effect. It just kind of carried on intentionally, unintentionally. I don't know. The same rubric is always announced in all of these retroactivity cases prior to Herbeck, but then, as I mentioned before, then it's kind of I know it when I see it sort of issue as far as whether it's remedial, substantive, procedural, emergency. There's a number of different categories that apply.
Leah's point in the concurrence in Landgraf was that if you looked at the timing of the thing at issue, it kind of tracks and follows the remedial and substantive distinction. And the courts were focusing on the wrong thing, which so if you have a jury trial after the enactment of a statute, that's prospective. It occurs after. I think that was the point he was trying to make, is that if we think about the question in the right way, the kind of remedial substantive cases fall in line with when the relevant event is actually occurring.
100% with that, Your Honor, and that's why at the beginning of my argument I mentioned that it doesn't matter in this case which analysis you use. It does track very well. You can apply the Herbeck analysis to Anderson. You can apply it to Phi Beta. I think the only case where it doesn't apply real well would be Mackey, which you dissented on, and that was before Herbeck. So for the most part, especially in cases that involve civil issues, it's not going to make a big difference, especially with the facts and the type of amendment that's at issue in this case. I believe I'm out of time. We would just, again, ask that the district court's decision in this matter be reversed, this matter be remanded for a trial, as the Supreme Court announced once before, for equitable relief as set forth in the statute that was in effect at the time of the reprisal or alleged reprisals that were alleged to have been made against Mr. Hedlund. Thank you.
The case of Hedlund versus State of Iowa is hereby submitted, and I believe I stated it before, the case of Story County and Story County Board of Review is also submitted, and court is adjourned.